The next one, number 8, Ombudsman's office said you could sign. Okay, so I hadn't done an Ombudsman's request for a while, and we're doing one, and it's easier for me to just do it for the client rather than give it to them. But I was under the impression that the client has to go and sign it. So I gave him instructions to fill out the form for the USCIS Ombudsman's request, and they're doing it, and then it was still a hassle. But then reading it or something, I realized that for them, a lawyer could sign on their behalf and submit it. Double check that, but again, I didn't take exact notes on the source of it. But I was like, good to know. So you could do that. But Ombudsman's office was at the USCI's, at the AILA conference, and they're really nice people. They just issued their new annual report, which I started reading. I'm going to go over it and have a separate podcast on that. But they could be really helpful in a lot of different things. And I'm going to ask him to try to help us out or help clients out on certain matters. Like, for example, the form IA-24, this useless form, that has delays. And the main reason I get clients based on this is because they fill out the I-130 incorrectly and they write adjustment of status instead of consular processing. And that causes them to need to do an IA-24 because the case gets stuck with USCIS, they don't transfer it. So I'm going to ask the Ombudsman's office to say, hey, USCIS, we'll just base whether they do adjustment or consular processing, base it on the current address of the beneficiary. So if they list that they're living overseas, the client shouldn't be able to need to specify whether they're doing consular processing or not, because they're not competent enough to know what the difference of this stuff means. You should just assume it and always, essentially err on the side of consular processing, because if you adjust later, it's okay. But if you say adjustment and you want to do consular processing, that's not okay. That creates a lot of problems.